Acceptance is an unequivocal assent to the terms contained in an offer. An acceptance can be express, for example, by spoken words or documents. Implied, for example, by the conduct of the offeree. Invalid acceptance. This includes silent acceptance, counter-offer, conditional acceptance, cross-offer and acceptance in ignorance of offer. Silent acceptance. In contract law, a valid acceptance must be communicated to the offeror. Simply intending to accept is not enough. The acceptance must be expressed in a way that the offeror can understand and recognize. For example, in the case of Feldhaus versus Bindley, an uncle offered to buy his nephew's horse, stating that if he didn't hear back, he would assume the offer was accepted. The nephew intended to sell the horse to his uncle but accidentally sold it at auction. The uncle sued the auctioneer for conversion. The court ruled that there was no valid contract between the uncle and nephew because the nephew's acceptance was not communicated to the uncle. Even though the nephew intended to sell the horse, the lack of external manifestation of his acceptance made it invalid. This case highlights the importance of clear and explicit communication in contract formation. Counter-offer. When someone responds to an offer by changing the terms, it's called a counteroffer. This new offer basically cancels out the original offer. For example, if you offer to sell your bike for 100,000 naira and the buyer says, "I'll buy it for 80,000 naira, that's a counteroffer. The original 100,000 naira offer is no longer on the table. The seller can either accept the 80,000 naira counteroffer or make a new offer. In Hyde vs. Wrench, Wrench offered to sell an estate to Hyde for £1,000. Hyde countered with an offer of £950. Later, Hyde tried to accept Wrench's original offer of £1,000, but Wrench refused. The court ruled that Hyde's counteroffer had terminated the original offer, so Wrench was free to reject Hyde's later acceptance. This principle has been upheld in subsequent cases. Conditional acceptance. An acceptance that includes a condition is not valid until the condition is met. For example, an agreement, subject to contract, is not binding until a formal contract is signed. This means that neither party is legally obligated to proceed with the deal. Cross-offers. A cross-offer occurs when two parties send identical offers to each other at the same time, without either party knowing about the other's offer. This is like two people offering to sell the same item for the same price to each other without knowing about the other's offer. These offers are not binding because they don't constitute an offer and an acceptance. The case of Tin versus Hoffman and Company illustrates this principle. Acceptance in ignorance of offer. If someone offers a reward for something, and someone else does that thing without knowing about the reward, they can't claim the reward. This is because they can't accept something they didn't know existed. The case of Fitch versus Snedeker supports this rule. This is because a person cannot accept an offer that he has no idea of. Communication of acceptance. In the case of Feldhaus versus Bindley, the court ruled that an acceptance must be communicated to the offeror for it to be valid. However, there are exceptions to this rule. In Carlisle versus Carbolic Smokeball Company, it was decided that for unilateral contracts, offers that require a specific action to be accepted, the communication of acceptance is implied. This means that if the offeror has made it clear that performance of the requested action is enough to accept the offer, the offeree doesn't need to explicitly tell the offeror they accept. Where the method of acceptance is prescribed. In the Nigerian case of Orient Bank versus Bilanti Intl, the court ruled that if an offer specifies a specific method for acceptance, any other method used will be invalid. Where the method of acceptance is not prescribed. If an offer doesn't specify a method for acceptance, the offeree should use the same method the offeror used to make the offer. So, if the offer was made verbally, the acceptance should also be verbal. If the offer was made in writing, the acceptance should be in writing too. Acceptance by post. There's an exception to the general rule that acceptance must be received by the offeror for it to be valid. When the acceptance is sent by post, it becomes effective as soon as it is posted, not when it is received. This principle was established in the case of Adams versus Lindsell. In the case of Household Fire Insurance Company v. Grant, the defendant offered to buy shares in a company, and the company accepted by mail. Even though the acceptance letter was never received by the defendant, the court ruled that the acceptance was valid because it was posted. This means the defendant was obligated to buy the shares, and when the company was liquidated, the defendant was held liable for a certain amount of money. Limitations to acceptance by post. If an offeror specifies a specific method of communication for acceptance, that method must be followed. In F. Holwell Securities Ltd v. Hughes, the offeror clearly stated that the acceptance must be communicated in writing. When the offeree accepted by post without the acceptance reaching the offeror, the court ruled that the acceptance was invalid. The rule does not apply where the letter of acceptance is wrongly addressed or inadequately stamped. The rule will not apply where its application will lead to absurdity or inconvenience. Revocation of acceptance. Generally, an acceptance can be revoked, cancelled, at any time before it reaches the offeror, unless it's sent by post. For posted acceptances, it's less clear whether revocation is possible. Once a letter of acceptance is posted, there's a binding contract as far as it does not fall under any of the limitations. In our next class, we will discuss consideration as the third element of a contract. Goodbye.